17th of January. And I have a couple witnesses, three witnesses to be exact, on H2, which we had a walk through yesterday afternoon, raising the age to 12 for delinquency. And we're going to start with Kim McManus, if that's okay, from State's Attorneys. I know I don't know if that's exactly what we have down here as the order, but that's where we're going to start. Yes, it is. How about that? Okay. Over to you, Kim. Thank you for being back.
Thank you for having me. For the record, I'm Kim McManus, Department of State's Attorneys and Sheriffs. We were asked to come in to comment on H2, raising the minimum age of juvenile jurisdiction from 10 to 12. Just as by way of a little background for the committee, the State's Attorneys and Sheriffs are a representative on the Racial Disparities Advisory Panel. So we were involved in the report that was issued last February. There were a number of recommendations in that report, one of them being raising the age from 10 to 12 for juvenile jurisdiction. And Tim Luders-Dumont, now our Executive Director, representing the State's Attorney's Executive Committee, did support this measure with the advisory panel, and we do support it today. The number of juveniles in this age group of 10 and 11 who would receive a juvenile petition for delinquent behavior is quite low throughout the state. I mean, there's instances of it, but it's quite low. And we do believe that the juvenile proceedings under a CHINS would accommodate intervening and supporting children if they were exhibiting that sort of delinquent behavior at 10 and 11. So we do support H2.
Okay.
How many are we talking about? You're quite low, my quite low, might be different.
My understanding that we're talking less than a handful. So 2 or 3 at any given time.
10 to 12.
From the ages of 10 and 11, so under 12. And it's a small number per county, but still a number. And again, that the behavior being
Per county?
yes.
Okay.
Yeah, so any given county at any time may have 0, may have a few, but it's never a large amount.
Okay, thank you. That's good.
Yes.
10 to 11 is sad.
But they're taking care of what happens with these children who are not like the currently 9-year-olds. What?
Again, that would be under the CHINS statutes. If the child's exhibiting behavior that's concerning, that they're out of control in some way, that they're going to need support, their parents are going to need support. There's juvenile proceedings that can address that outside of the juvenile delinquency. So for this age group, we are not concerned about raising the age to 12 as a minimum.
Karen.
I don't know if this was the question that you were asking, Chair, of that piece of the CHINS piece. So we've spent a lot of time understanding the juvenile justice piece of it. And I don't know if this is a question for you, but I just don't understand what a CHINS proceeding would look like. Is it, you're saying like it would be to address concerning behavior? If you can share.
I can to the best of my ability. So when you look at the juvenile justice proceeding statutes, it's broken down into a few sections. One is delinquency. One is, I always have to check the name, child in need of care or supervision. And there's 4 types in the definition section, A, B, C, and D. And those are for different scenarios. I can read out those scenarios if it's helpful to you as far as what would fall under those.
Sure.
So a CHINS A would be a child in need of care because they have been abused by a parent or custodian, or they have been abandoned. So that would be that scenario. CHINS B, a child is in need of care because they are without proper parental care necessary for their well-being. CHINS C, a child is in need of care because they are beyond the control of their parent. CHINS D, a child is in need of care and supervision for being truant, parenthetical, absent from school without justification. So those would be 4 slots that potentially a child's behavior, if it's concerning, could fall into. Ledge counsel on the first day of the juvenile justice hearings was going through juvenile justice proceedings, how there's that sometimes an emergency care order, a temporary care order, that falls into, that would, some of the delinquency proceedings mirror how a CHINS proceeding happens. You know, if a parent and a child have notice, they go in, they have an initial hearing, and then there's, you know, many hearings to figure out whether or not we're meeting the definition. Like, does the evidence support one of these? And then there would be essentially a disposition plan.
Oh,
Go ahead. Oh, no.
With the delinquency, it would be creating, you know, if they go for it, a plan, disposition for the child or the youth, whatever. With CHINS, is it more, it could be for the family, it could be creating a plan. It's not just for the child, it's for the well-being of.
That's my understanding.
Okay.
I mean, it falls under child welfare, so it's very much focused on the child, but I do believe, that the parent and guardian are pulled in, you know, they may have to do certain things to keep, and again, depending on which one, but yes, this would all fall under child welfare.
Okay. And now 10 and 11-year-old with this proposal, if this bill would go into that system that already exists for 9 and younger.
Oh, no, and CHINS exists for all
ages.
children.
Yep.
So sometimes, basically this bill in front of you does not impact CHINS at all. CHINS is always a tool that can be used. And sometimes they do overlap. Sometimes we'll have a child exhibiting behavior that is delinquent. We also know there's some other things going on that maybe is contributing to that. And so sometimes there's both, or sometimes the CHINS can take care of it. The petition's not necessary. So for this 10 and 11 group, what we're stating is that for that behavior in that age group, even if it is technically delinquent, we believe the child would be able to be supported and the family would be able to address the issue under a CHINS.
Sorry.
That's okay.
Did you have a question?
No.
Okay. Are we all set? Any other questions?
Yeah, like,
Yeah.
is there any other states with similar as far as the age thing goes? I'm just curious.
I'm so sorry.
Any other states have a similar setup as it?
You know, off the top of my head, I know they vary across the country as far as what the minimum age is, but I wouldn't know the average.
Not that it matters either way to me.
Yeah.
I'm just curious.
I don't know off the top of my head.
And I'm gonna assume that there's gonna be so few cases, like you said, that it's not gonna tax any services.
I don't think so. And again, the 10 and 11 group, I think there's already a lot of overlap potentially. If a child again is exhibiting this behavior, that would be delinquent, there's more than likely a CHINS piece, not exclusively, but I don't think that we're suddenly going to be sending a ton of cases over to the CHINS docket. Yeah.
They're already in the system.
And again, I couldn't, it's more than likely that there's some overlap.
Thank you very much.
Thank you.
So actually, we're going to go to Susanna Davis next, and we'll end with Matthew Bernstein. So thank you for being here, Susanna. Over to you. Identify yourself for the record and proceed.
Yes, thank you for having me. Good afternoon. Susanna Davis, Executive Director of Racial Equity. I am here, I suppose, representing the Office of Racial Equity and also the Division of Racial Justice Statistics housed within our office. And my testimony actually will be kind of brief. The Office of Racial Equity supports the raising of the minimum age for juvenile justice proceedings from 10 to 12. This is something that the office supported as a member of the RDAP, the Racial Disparities in the Criminal and Juvenile Justice Systems Advisory Panel, when it made that recommendation in its February 2024 report. And I'll just leave some breadcrumbs here for any viewers who want to reference the report. The recommendation text is on page 5 of that report, and there is actually a map on page 21 of the report that shows Vermont as actually being an outlier among neighboring states regarding minimum ages. We have states like New York and Massachusetts with 12 as the age set. We've got states as close as New Hampshire that have a minimum age of 13. So it seems very much in line with where the current science around psychology, criminality, and intervention for youth is headed, and we would support this measure. I want to note also, again, because this was a recommendation in the RDAP report, and this is something that our office supports naturally, just as with many things in life, there are racial equity implications, and it's important that we consider those as we do this work. Raising the minimum age is not only something that's going to be beneficial to all youth, however, it's going to be particularly helpful because in this country, there is a phenomenon that's commonly referred to as the adultification of children, particularly Black children. This is something that's been discussed generally in society in the US, but increasingly in the justice system as well. And I want to actually borrow some words from the Center for Policing Equity. They talk about the adultification of Black youth, and I think that it would be helpful to hear, as they put it really succinctly. They state that the period of time during which white youth are not expected to be fully responsible for their actions can extend well into their late 20s. By contrast, Black children are often treated as adults by age 13, if not well before, regularly perceived as older, less innocent, and more threatening than their white same-age peers. Of course, they go on to say that this is particularly true in cases where they're experiencing contact with the criminal legal system. As a matter of fact, in 2022, the Washington State Appellate Court published an opinion that actually acknowledged this phenomenon. And they said, and I'm going to borrow words from that state court, they said, adultification is real and can lead to harsher sentences for children of color if care is not taken to consciously avoid biased outcomes. The reason this was meaningful, for besides obvious reasons, was because this actually happened about 3 months after the Connecticut State Supreme Court had to acknowledge that the penalty, the sentencing of a then 14-year-old in Connecticut was imposed illegally and was really a direct result of this adultification and specifically this concept of the super predator theory. I won't dive into that. It's a lot more theory than needed to explain our stance here, but suffice it to say that when we talk about raising the minimum age, we're not just supporting better outcomes and more opportunities for intervention for youth across Vermont, but we're also creating codified stopgaps for ourselves to ensure that we're not as easily engaging in practices like adultification, particularly when it comes to youth of color who are more vulnerable to us doing that to them. The last thing that I'll say here is that while this is something that we do support, we also just want to make sure that we're not just going to stop here, and that we really take a look at the juvenile justice system and look at the young people who are going to remain in it. Regardless of what we make the minimum age, we're still talking about vulnerable youth and thinking about, this measure is not necessarily going to help those who are 12 years and older, but there are other interventions that we can make to make sure that we minimize their contact with the justice system, and that when they do have contacts with it, that those contacts are approached from a holistic standpoint that's not going to serve to be punitive and ruinous to their lives, but rather more rehabilitative and supporting. So I'm thinking a little bit about an analogous example about, benefits programs or student aid, right? There's always a cutoff income. What's really the difference between a person who earns, $15,999 versus $16,000? Maybe there's a cutoff, and I've made these numbers up. Maybe there's a cutoff, but those people who are $1 up are still probably just as vulnerable, right? And in the same way, we might raise this age from 10 to 12, and I think that that's a good thing to do. But let's still look at those 12-year-olds and the 13s and the 14s, and really make sure that we're not leaving them with any heightened vulnerability as the sort of youngest ones in this class we're talking about. I will leave it there. I thank you for your time, and I welcome any questions you may have.
Thank you. Questions? You're catching us on a Friday afternoon, apparently after a long week, and we've exhausted our questioning, which is either good or bad. I don't know, but thank you very much, Executive Director Davis. Appreciate it. We'll be seeing you again fairly soon. I am going to we tried to get you in next Friday. I understand you're unavailable for, we really want to have you review a very good report that you just came out on January 15th. From the Office of the Division of Racial Justice Statistics. So I'd like to dig into that. So we'll look forward to that in the next couple of weeks or so. But there's a question now.
Not a question.
Angela.
It's not a question.
Oh,
So
not a
maybe that's
question?
why I didn't raise my hand on it.
Yes.
But I just wanted to say thank you, Susanna, and thank you to you and your office for always raising the important points that often get overlooked, and the ways that we can in making changes like this that may seem small or slight, that we can really start to dismantle some of the systemic oppression and aggression, and how important it is to take those opportunities when we have them and to create them when we don't think we have them. So I just want to say thanks for that.
Thank you. Thank you all.
All right. Have a good weekend. Thank you.
You too.
We'll go to Matthew Bernstein now. Thank you for being here. And if you identify yourself for the record and proceed.
Thank you. Excuse me. Matthew Bernstein, Child, Youth, and Family Advocate for the state of Vermont. And I am so sorry that you are ending your week with me testifying, but you've done it to yourselves. And I'm also sorry I can't be there. And I'm also sorry that I can't share my screen, Nate. So if you could give me that ability, that would be awesome. Thank you. So I just have, for those of you that saw us present earlier in the week, just a couple of slides, so don't worry. Let's see here. All right, let's see if you can see that. Can you all see that?
Yes.
Slideshow, whoopsies. And I somehow need to bring it over to this other screen. I don't know how to do. Oh, well, forgive me for looking over here, but just juggling all the technology. I think most of you know what our office is and is about. I've left this slide in the presentation. I will highlight the last bullet point, which is our office is tasked with promoting reforms necessary to better serve Vermont's children, youths, and families in a manner that addresses racial and social equity. And that, as we've heard already today, very much applies to this bill. So you all know this. I just wanted to walk through it very quickly. Essentially, what does H2 do? Raises the minimum age for juvenile jurisdiction and also maintains the ability to prosecute a child of any age for murder. And that is a very specific and, elevated charge that has its special status, and that could be its own conversation, but that's not what we're talking about today. That will remain, if H2 passes, that will remain, as you all know, within the realm of prosecution. A child of any age can be prosecuted for murder. Okay, so I think just a couple of things to think about for you all in terms of why we have a juvenile justice system, and what the minimum age should be, because as Ms. Davis just said, it can be arbitrary where you draw the line, right? And should always be making individualized decisions based on the child in question and the alleged infraction, et cetera. But so this is like kind of law school 101 stuff that's kind of fun. And there's different ways of thinking about this, but one reason we might prosecute anybody is so that they can be rehabilitated, right? You prosecute them and then you help get them services and supports so that they can turn around whatever issue led to the infraction or the alleged infraction that they committed. Another one might be restorative. So we talk a lot about restorative justice. We talk about the BARGE program. Balanced and restorative justice is what that stands for. So that's, you want to also address the victim, right? And you want to repair harm, right? So it's not necessarily just about prosecuting the child, but also about repairing the harm that occurred, with this sort of vision of a bigger social fabric. You might you might have a punitive reason to punish, to bring somebody into the criminal justice system. You simply say what you did was wrong and you deserve to be punished. That is an old classic that remains, right? Is that you do wrong and then sort of wrong is done to you. And then another one could be removal. So in other words, and this could apply to children as well. A child has has a substance use problem and might need medication for a mental health issue. And what they really need is to be sort of removed from the general population and supported with those things. And then when they're ready, they can kind of re-enter. And then lastly, and again, these are not set in stone. These are just different ways of thinking about systems, and there are certainly others. So feel free to jump in with your own. But transformative might be sort of some of what Ms. Davis was talking about and others have talked about, which is how do we transform our systems so that we can support children, youth, and families, and how do we, as policymakers, I think, I always want to hold the mirror up to us. Like, what are we doing to make our systems better so that, harm isn't done, first of all, right? And we're also not, criminalizing younger and younger children. So these are just different ways to think about this, and I'm not saying any one of these is better than others. I may have neglected to say our office supports H2. Before I go any further, I just want to say, get that on the record. We support this bill, and we think for all the reasons that the previous witnesses have laid out, the RDAP report, that it is the right thing to do. I wanted to give you another little bit of additional information because I know this was coming up. So this is data that we got from the crime research group, and as with all data, it has lots of caveats. So this is from January of 2021 through September of 2024. There's no particular reason that's the data set, but just to say that that's what it is. So it's a little more than 3 years. And these are listed. I took off the column that had case number, but I do have the actual case number. So each row here is a case number. So that may be, a single child could have multiple cases, and there's others that are more qualified to talk about why that might happen. So I just want to emphasize it's not necessarily, each one of these rows is not necessarily a different child, right? There could be some overlap, but these are, to my understanding, all of the docket numbers for cases that went to disposition when the child was the age in the age column. So in other words, it's not necessarily the child could have committed the crime, for the 11-year-olds on here, for example, at age 10. The age listed on here is when the disposition happened, and that's obviously it would make more sense to have data with the age of the child at the time of the alleged infraction. And just because of the way this particular data was collected, I don't have that for you today. So I just want to make sure that that's clear. But with all of those caveats, these are all of these. The next line under the last row here has the number 12 on it. So this is everybody under the age of 12 who hit disposition at that age over the last 3 years. And as you can see, it's not that many. I know there was some discussion earlier, and you can see the offenses on the left. And there's some concerning things on here, right? Burglary. You wonder how an 11-year-old or younger commits burglary. You could think of different ways in which that could manifest, right? It's some less concerning than others, some very concerning. I think you see a lot of unlawful mischief, disorderly conduct. Are things that are, they are concerning. I think they are, my perspective on it is an 11-year-old who commits that infraction. It goes back to the discussion you all were having earlier. What's going on in the home? How can we support you? What services do you need? What's going on? So
before you proceed,
yes.
Question here.
Yep.
Hi, Matthew. Thank you very much.
Yep.
How many distinct cases is this?
As I said, I don't. Oh, are you saying distinct cases? Is that what you're saying?
Well, yeah.
Each one of these.
You took the docket numbers off. So, and I'm assuming it's for confidentiality. So, if you were just to look at that column, could you just? I mean, it's not that many. So I'm just curious. I think it would be an interesting number to have for us, just like how many cases of this, because I like your point is well taken that like what like for 2023, right? Like one
Yeah.
case could be actually like a ton of those charges if it was a really complicated situation. So I'm just curious if you have or if you could have that number.
Yeah, my understanding, and this is a better question, I think, for prosecutors or perhaps for Marshall Paul, because I don't work in this field every day and know how, every state has different customs and procedures for docketing. My understanding is each one of these each one of these rows is a separate docket number. So yes, so that's what I was trying to convey earlier. So I
Oh, I
believe they are each
misunderstood
an
that.
individual case.
Oh, okay. I
I can
apologize. I
confirm
misunderstood.
for you. I can confirm for you, following up because it's complicated. So I make sure I understand your question. You want to know how many different cases this is, or do you want to know children?
I guess I was just I thought that you had lined up kind of like all of the time someone was charged in the ages of 10 and 11 for the last 3 years. And I was just curious, like, how many of those, like, how many children was that and how many cases was it? I think I didn't understand
Okay.
that these are each individual cases, but your point is
Yes.
that these could be like the same kid, but in a different case.
Correct.
I
That is, I believe that is
Okay.
correct. There are not more than these to my knowledge. So I think it is safe to, yes, it is
Okay.
safe to assume all of these are a separate case, i.e. docket number. There may be fewer children than the number of rows because one child may be involved in more than one case or docket number. Is that clear?
I thank you for the clarification.
Okay.
I think
Yeah.
the point is well taken that it's not very many. So
Okay. Yeah.
I-
Yeah. And I don't have the county numbers. I think that would be interesting. I know there was testimony earlier about number of cases. So and as with all data, it's partly limited to our systems. One reason this is January 2021 is that's when our new data system came online here. So just to move it along, unless I can't really see the room very well, so please interrupt me as I go. But so this is a slide, as you can see, it's another different style. This is from some data it's judiciary data, as it says. This was presented at the Council for Equitable Youth Justice. And so this is delinquency filings. As you see, this is federal fiscal year 2021 to federal fiscal year 2023, which is different than state fiscal year. And it's not, again, I want to emphasize, this is just another way of thinking about this. The reason why I have this here, it stands for something that Ms. Davis brought up earlier, which is the way in which Black youth are often charged, the assumptions about Black youth. And again, I want to emphasize this is like structural stuff, right? So it's not to say like, it's not to assign intent per se. But as you can see, the numbers for the Black youth are a little bit upside down. And I referred to this in my testimony Tuesday. Or Wednesday, sorry. So, as you can see, for 15-year-olds, for Black youth, the number 15-year-olds are charged more than 16-year-olds, are charged more than 17-year-olds, are charged more than 18-year-olds, right? And as you see with white and other races, Asian is a little bit so few, it's hard to see. But this is one reason why you want to ensure that children aren't, younger and younger children aren't unnecessarily brought into the criminal justice system. And I'll just bring up one more study that was done that I'm sure some of you have heard of. It's a famous study. There was a study of where essentially this is a preschool study, and they had all of these videos that they would show just, I think it was actually just members of the public, not preschool educators, although I could be wrong. Anyway, they took these different videos of children in behaving certain ways in classrooms, and the kicker, the twist was that none of the behaviors in the videos were deemed by these researchers to be concerning behaviors. But what they asked the people who were watching them to do was to identify concerning behaviors. And what the study showed, in essence, is that Black children and brown children were over-identified as demonstrating concerning behaviors. And especially out of that study, partly, and others, came this notion of the 3 Bs, big, boy, and Black. the bigger you are, if you're a boy or a boy presenting, and if you're Black, you are much more likely to be perceived as exhibiting unacceptable, concerning, or criminal behavior. This is structural stuff, so I don't want to I think it gets into some big ideas about that have to do with deep set assumptions and norms, not like the intent, the conscious intent in the minds of people. But I just wanted to present this because I think it's really interesting, and it sort of surprised me when I saw it. So that's the end of my show. I had a couple, I'm going to stop sharing if it was, and I had a couple of other things I just wanted to say quickly based on what others said. So one thing I wanted to say is that the criminal justice system and criminal statutes often lag behind scientific knowledge, social norms, and for example, and this goes very deep. So it was only in the 80s where we ended the death penalty for people who have significant intellectual disabilities, in a case called Atkins versus Virginia. It was in the 21st century when we ended the death penalty for children. And the Supreme Court, the United States Supreme Court, is increasingly has issued a series of decisions, with bumps along the way that have sort of raised protections for children who commit crimes. And it can get very complicated, so I'm not going to dive into it. But I just think it's worth understanding that it takes a long time for our criminal justice system to catch up to what we know scientifically about children, and to changing social norms. And one of those is, to refer to another discussion from this week, children are the mental health outcomes for children are declining increasingly. The externalizing of those behaviors, interestingly, are also declining. So, youth crime since in the last 30, 40 years has just, I'll bring a graph next week in the Raise the Age testimony, but the numbers, it has just gone steadily and steadily down, right? And I think Representative Arsenault, you pointed out, and it might belie that to know, the youth risk behavior survey is revealing more and more, stresses for children and for families, and more internalizing and depression and suicidality and actual suicide. So, that all of that sort of points to, that transformative piece, which is really our job as policymakers and as the government to support children and families. And so that brings me to the CHIN system. And I guess I would just highlight, and I was just having earlier today a conversation with some school folks who I think were really articulate about this. Families and children need support, and how that happens is something that is really on us to I think re-envision, by which I mean the CHIN system. The main tool of that is removing a child and or eventually potentially terminating the rights of the parent. That is the hook, right? That is the thing that hangs over the head. And those are really blunt objects to address things like something that might cause a 10-year-old to engage in criminal behavior. And the schools where they come into it is, they're sort of calling DCF and reporting things like truancy to the DCF hotline. And a lot of those calls DCF screens out. We're number one in the nation in calls to our child protection hotline per capita. And, some of that, these school folks help me understand, is because they're really wanting support and help for these families. And they're calling DCF because they don't know who else to call. And so, what our office recommends is sort of to bridge that gap would be, as I said this week, more services under Medicaid using federal dollars, more support for families, and also relatedly a warm line. So that would take a lot to set up, but I think it's an important goal to move towards. So that is essentially, if you have a concern about a child, whether it be criminal or truancy, it's a number you can call to help get support for a family that isn't, just asking for a child welfare investigation, but that might be helping to get concrete and economic supports for that family, housing, relief from abuse, substance abuse support, things like that. So I know I'm going kind of deep on this. I will stop. But I think that this conversation really asks us to dive really deep into what what our role is as policymakers, not just in the criminal context, right, but also in something that's more supportive and really recognizes the deep struggles that families are facing. So I will leave it there. I will take any questions. I thank you for your time.
Any questions? I think that was fairly straightforward, so I definitely appreciate that. Just with respect to chins, so before this session and conversations with you and others, there are various issues that kind of are in the chins processing in the courts that we deal with a little bit more than we want to actually deal with this session or can deal with. But we're probably going to have a bill that will put together a task force to look deeply at the chins law and come back with any recommended tweaks for next session. So since you mentioned chins, I just wanted to touch on that. So I thank you very much, and we will see you again on Tuesday of next week. Have a good weekend.
Thank you all. I appreciate it. Take care.
Thank you.
Thank you.
And before we go off live, we'll stay on live for just a second. Just a preview of next week for folks real quickly. So on Tuesday and Wednesday, we'll be taking quite a bit of testimony on Raise the Age, just Wednesday morning. Then in the afternoon on Wednesday, we're going to take up H27, which is an act relating to domestic violence fatality review commission. It's my understanding is mainly adding some individuals and some definitional issues. Should be straightforward. There's no such thing as a simple bill, but it should be a straightforward bill. And we'll continue with that testimony after the floor. On Thursday, joint session with the Senate Judiciary, and we'll be going over public safety and court processing on that day. And we'll, in the afternoon at 1:30, we'll actually have a later start on that particular day after lunch. We're going to hear from Jay Johnson and Tucker Jones to go over the omnibus public safety bill and just present it so we can understand what that's about. And then finally on Friday, we're going to try to have a vote on H27, the bill that we will have heard about a couple of days earlier. And we're going to take up H41, which isn't quite on our, which, do you want to just say what it is real quickly?
Yeah, it's a, to make it a felony to move or deface a corpse. It's a misdemeanor charge right now.
Right.
Depending, it's an enhancement to a murder charge now, but this will make it a standalone bill, so it could be charged separately.
Right. So we'll take that up, and so that's next week, at least as it's planned right now, and we'll change 15 times during the course of next week. So, any questions on where we are with that, or just generally?
I might have missed it. Did you schedule a vote on H2?
Not an H2.
Okay.
No, we're going to have some more witnesses, which I don't have scheduled for next week, but we'll get back to H2 as well.
Gotcha.
Real quick, where H41 came from is the elderly lady that was killed up in Enosburg. I think it was early last year, late the year before. And
Thank you, Kim.
she'd end up missing for 2 weeks, and then they finally found her body somewhere else. That's where it came from, as the family requested.
All right. So thank you very much. We're